All right, well, welcome everybody. This is Adam White, a resident scholar at AEI, and as some of you know, a faculty member here at the Hertog Foundation. And it's a real honor and pleasure to be here tonight to moderate this conversation with Judge Don Willett. You know, a few years ago, George Will wrote a column back in 2015 talking about a variety of constitutional issues. And at the end, George Will offered his view of what the next Republican president should do when it comes time to appoint judges to the Supreme Court. And Will wrote, I quote, "To his first nominee, the next Republican president should simply say, 'Welcome to Washington, Justice Willett.'" Well, he hasn't made it to the Supreme Court yet, but he's taken a pretty big first step, moving from the Supreme Court of Texas to the Fifth Circuit in the Federal Court of Appeals system. He spent 12 years as an associate justice on the Texas Supreme Court before joining the federal bench in 2018. He's known, to put it mildly, he's known for his lively style and readability in his judicial opinions, which our audience got to enjoy while completing the assigned reading for our conversation. The judge's concurrence in Patel versus Texas Department of Licensing and Regulation. And for those of you who enjoyed reading the shortened version, I really encourage you to read the full version and anything else you can come across by the judge. He's just a remarkable writer and legal thinker. Before joining the federal judiciary, he held the title of Tweeter Laureate of Texas. I'm not sure if that was a compliment or an accusation. It was an honor bestowed for his innovative use of social media to demystify judicial proceedings and really bring the work of the courts and the Constitution itself to the public. And he's probably the only judge to appear on a Supreme Court shortlist whose past work includes a stint as a parochial bull rider. We're going to get into that in just a second. In the first half of the conversation, I'll pose a few questions to the judge. We'll then hear questions from 3 political studies fellows who have submitted some questions in advance, and then we'll take questions from the larger audience. You can submit your questions via the Zoom Q&A function. If your question is selected, you'll be recognized to ask your question. But please don't wait. Feel free to start queuing up questions in the chat function now. Judge, welcome. Thanks for joining us.
Hey, Adam. Thanks. I'm honored to join you. Appreciate it.
So as I suggested in the intro, you've had a pretty astonishing career, not just your legal career, law clerk on the court where you now serve. You worked in private practice. You worked for Governor Bush, and then the 2000 presidential campaign and the White House, the Justice Department. It's hard to keep up with all these. Deputy Attorney General of the state of Texas, and then you served on the Supreme Court of Texas and now a federal circuit judge. And outside of all of that, you've been both a bull rider and a professional drummer. So I'm not going to ask you what was your favorite job overall, but I will say, what was your favorite job inside of the law and what was your favorite job outside of the law?
My rodeo days were really during my early teens, riding bulls and bareback horses. And I didn't do it very long, not more than a couple of seasons. And I probably spent more time kind of hurtling through the air, screaming, than I did actually riding. But my rodeo days, you know, they really did, believe it or not, instill some life lessons that are somewhat relevant to my day job now. Number one, and you got to hold on tight, whatever you're doing. Life personally, life professionally is unpredictable. It's chock full of serendipity and divine happenstance. And so when things do go your way, don't gloat about it. And when things don't go your way, don't wallow about it. I also did play the drums in different bands and bars and clubs around the Dallas area. I worked at a video arcade. I worked at a putt-putt course. I pumped gas at a gas station and taught an LSAT prep course and lifeguarded and waited tables at a steak restaurant. So, but inside the law, I think my journey has been really admittedly unorthodox. I've been fortunate, as Adam mentioned, to work for a federal appellate judge in a large Texas firm and a Texas AG and a governor and a US AG and the president. And I think that varied experience has really bestowed a key virtue. It helps me to know judging and to know policy making and to know the difference. And I think as judges, we're all a product of our professional backgrounds and experiences. And I think my service in different branches of government on both the state and federal level maybe makes me a little more attentive to constitutional building blocks, architectural features like separation of powers. And on a multi-member appellate court like mine, we thrive on spirited, vigorous intra-court debate and intellectual give and take. And I think it sharpens our analysis to have people drawn from different occupational backgrounds, to have a measure of career diversity on the court. And I think there is actually a strong body of academic research on how career diversity on a collegial multi-member court can really produce more refined opinions. So I have worn a lot of legal hats. I think the one I wear now kind of fits me best. I think I am metabolically hardwired or engineered for this cloistered and contemplative and monastic, ultra nerdy life of appellate judging. And I can imagine a lot of legal jobs that pay more, but really none that are more rewarding in every sense. I mean, I revere the law. I think it's a majestic thing. And I think when the title judge or justice is conferred on somebody, I think that profound majesty is placed in human hands. And it is something that affects the life of every single American. I think judging is a really noble enterprise. And, Socrates, 2,500 years ago, he said 4 things belong to a judge. Number 1, to hear courteously. 2, to answer wisely. 3, to consider soberly. And 4, to decide impartially. So no finger on the scale, no finger in the wind, just utterly impervious to these gusts of popular opinion or editorial board criticism or the desire to be invited to cocktail parties or whatever. So I have life tenure because the founders were really concerned about judicial independence. The Declaration itself talks about an independent judiciary. It was one of our main beefs with King George III was, he has made judges dependent on his will alone. That's how Jefferson wrote it. And as part of that long train of abuses and usurpations that the Declaration talks about. So I think what was true for the American Revolution is also true for the Texas Revolution. Sam Houston, the first president of the Republic of Texas, he said an able and honest and enlightened judiciary should be the first object of every people. And I think Americans deserve to have the utmost confidence in their judges, to believe unshakably that we call it straight, that we're not ideological combatants, we're not philosophical crusaders, seeking to gratify a personal agenda or impose our own subjective view of how the world ought to be. So I think if there were a paramount attribute for a judge, if you were writing a job description, it'd probably be just surpassing fidelity to the rule of law. We are, like John Adams said, a nation of laws and not of men. And so that rule of law, those sacrosanct guardrails, are really indispensable. The rule of law isn't simply whatever judges decide to do. Our nation's founded on we the people, not we the judges or anything else. And the judiciary, as I see it, we're emphatically a legal institution. We're not a political one, and we're not a cultural one. At least we shouldn't be. And I think judges ought to always act judicially by adjudicating and never politically by legislating. And I think our North Star has to always be legal principles and never personal preferences. And my job isn't about aggrandizing power. It's not about indulging a personal agenda. It's about fulfilling this sacred legal duty. So I think I'm clear, having worked in these different branches, state and local level, I'm clear on what my job is and on what it's not. And I'm clear that my branch we kind of squander our legitimacy when we kind of stiff-arm the law to reach wished for policy outcomes. And truth be told, the only real meaningful check on a court's power is its own real ethic of self-restraint, what Justice Frankfurter called one of the greatest duties of a judge, the duty not to enlarge his authority. So I guess the bottom line is the judiciary's role in our system is consequential, no doubt about it, but it's also confined. And judicial review, deciding whether laws comply with the Constitution, it doesn't give judges like me freewheeling power to impose our own personal whims or any kind of result that we might find more personally, ideologically congenial.
We'll get back to the work of judges in just a moment, but before we do, I do want to pause briefly on another one of your experiences in your career, a pretty extraordinary one. And this was back in 2016 when then candidate Donald Trump announced his list of prospective Supreme Court nominees, and he took George Will's advice, putting you on, so to speak, putting you on the list. And I'm just curious, what was that experience like? When did you find out that you were on the list? Did you get a heads up in advance, or did you read about it in the news? And just in general, I can't imagine what it's like to find yourself in those circumstances. So I'd be curious to hear about it.
I tell you, it was truly an out-of-body experience. And I received no heads up at all. And if I had, I definitely wouldn't have been where I was, because the news broke at the worst possible time in the worst possible place. I had just devoured some really tasty Texas barbecue, which I know is redundant, but some really good barbecue with my friend who tweets under Iowa Hawk Blog, who some of you may have heard of. So he and I had just wrapped up some barbecue, and he had dropped me off downtown because Governor Abbott had just written a new book, and he was having the kickoff to his book tour in this really cavernous auditorium, and it was vacuum packed. People were really kind of squeezed in like sardines. So I had just arrived late at the Abbott book tour kickoff. And I sneaked in the side door, and one of the staff members said, "Hey, Judge, I think there's one more seat down that road. Just scoot on down and take it." So I'm scooting by people, and Governor Abbott kind of spots me. And I had just written a few days before the big school finance case on the Texas Supreme Court. So he paused his remarks, and nobody knew anything yet about the short list. And he said really gracious and generous things, and people clapped, and I waved, and I sat down. And as I sat down, my phone began just going berserk in my pocket, and I fished it out, and it was lit up like a Vegas slot machine. And I was just kind of dumbstruck. And I had about 30 seconds to process it because Governor Abbott was wrapping up his remarks. And I'm trying to piece it all together, kind of tweet by tweet and text by text, and just all these little fragments. And I had about a minute, and people are clapping, the event is over, and I look up from my chair to find myself surrounded by the entire Texas Capitol press corps, because they were all there because it was the kickoff to the governor's book tour. And this really polite but persistent mob of media made their way to me. They could not believe their luck that the news broke. They got the news when I got the news, and I was just a few feet away. So they made a beeline for me. And I looked up and found myself surrounded by iPhone cameras and tape recorders and microphones. And they were all I knew all these reporters. I had a really good relationship with them. And they were all just kind of amused at my dumbstruck sort of judge in the headlights reaction. You know, one reporter, I think, described me the next day as sweetly flustered, is how he put it. And I really couldn't muster even a tweet length response. And I think I muttered something about needing to exercise some judicial restraint in that moment. And I kind of skedaddled, but my synapses were not firing very quickly. And I made a beeline from my office, and I turned on the TV to find Jake Tapper kind of live on the air, kind of scrolling through and reading my Twitter account on the air. And then that night, Jimmy Kimmel is reading my tweets during his monologue. I guess the plus side, I gained about 10,000 new Twitter followers that day alone. But it really was an otherworldly honor to be mentioned alongside those 10 other folks. I knew most of them. I respected all of them. And to be named alongside them for any reason was a really rich honor. They're all exceptional jurists. And interestingly, over half of them either were serving at that time or had served in the state judiciary, where the overwhelming bulk of American justice is dispensed. But I think politically, the announcement was really a genius political move. It certainly raised awareness of the obscure judicial branch, which is I think a noble civic good. The judiciary, as we know, it flexes profound power over people's lives, and if you ask me, doesn't get nearly enough attention from presidential candidates. So if anything, I think White House contenders ought to talk more about the judicial branch and our proper constitutional role.
Well, and it's interesting in that respect that in this election cycle, Vice President Biden either hasn't issued a list of his own or hasn't yet issued a list of his own. It'll be interesting to see what happens if he does. But just looking at the list and looking more broadly at the body of conservative judges, which now includes all the number of judges who President Trump has appointed to the federal courts, conservative and libertarian judges agree on a lot. Most of them start with the text of the law, like whether it's the Constitution or a statute, and try to understand its originally understood meaning. But for all of their general agreements, there are some interesting disagreements, sometimes very subtle, between various judges who you generally lump together as libertarian or conservative. So I'm curious, how would you describe your own approach to the legal or judicial task of interpreting the law and deciding cases?
That's a great question. There is kind of this silly, in my view, lazy, in my view, perspective that the so-called Trump judges, that we all march in ideological lockstep, and the facts are hostile witnesses. And there's this great Federalist paper, number 20, which I think was a joint Madison-Hamilton product. And there's a great line in there that says, "Experience is the oracle of truth." And the real world truth is that President Trump's appointees have engaged in, frankly, some really spirited, no holds barred legal debates in their opinions. And sometimes we do nod heads, but just as often we butt heads too, and things get kind of feisty. And I think one of the most vivid examples, which I know you're aware of, concerns the doctrine of qualified immunity, this judge invented doctrine that shields government officials from being sued when they violate somebody's constitutional rights. They're shielded so long as the wrongness of that misconduct wasn't, quote, clearly established. And there is a growing cross-ideological chorus of judges and scholars that are urging the U.S. Supreme Court to sort of recalibrate and rethink the modern immunity regime, because critics believe it allows a lot of it allows a lot of constitutional violations to slip unchecked. And I'm one of those judges who has urged refinements to qualified immunity. In fact, I've written that sometimes qualified immunity smacks of unqualified impunity, and I've butted heads with some of my fellow Trump appointees over the real world functioning of modern immunity practice, and which I've described as essentially heads government wins and tails plaintiffs lose. And in my view, too many wrongs are not righted, and too many people are left violated but not vindicated. And I don't believe that immunity should itself be immune from smart refinements that more fairly achieve its intended policy goals. But President Trump's appointees, we've sort of bickered about that very publicly. As for language and the judicial task, I'm a resolute, unshakable, unswerving, unflinching textualist. I want to give words their soundest and most honest reading. The lion's share of modern appellate judging, like I do, is not about imposing a result that strikes me as personally fair or equitable. The 21st century appellate judging, the business of that is really about reading words on a computer screen and deciding what they mean. In law school, as Adam knows, you go to law school, you read these tour de force, eloquent opinions by these legal titans like Learned Hand and Benjamin Cardozo, most of them sort of common law cases where the judge is kind of imposing their own personal vision of justice, what strikes them as personally fair. It kind of strikes an itch. But we don't really inhabit that legal world anymore. Most of it today, as lawmakers enact new laws and regulators enact new regulations, we spend time reading those words and deciding what they mean. So I'm a diehard textualist, which isn't to say I'm a literalist. Textualism isn't literalism. I aim to read language common sensibly. I try to discern it and not distort it. And I try to give the words their most forthright meaning. I think judges have to have a scrupulous fidelity to text. We have to give it not just a bearable interpretation, but the most textually plausible interpretation. And interpretive context is everything. You've got to have a reading that is anchored in textual and structural evidence, because words are slippery. And good faith textualists can and do read text differently. I give my future law clerks a pretty vast reading list, and the one I most urge them to read and then repeatedly reread is the book called Reading Law, which was a joint product of Justice Scalia and Brian Garner. And there's an epigram printed at the very beginning of the book. It's kind of this medieval legal maxim printed in Latin, but translated it means hold tight to the words of the law. And I think principled textualism is 100% apolitical. But I think ascetic, literal parsing isn't textualism. I think statutory meaning derives from linguistic and semantic context. And I think judges play a really critical, what some call a lexicographic role. And in my view, that role is to give words their most honest and straight up meaning, which doesn't mean that textualists agree on everything. I mean, trust me, we do not. And we recently saw a pretty high profile example of that at the Supreme Court in the recent case about whether federal anti-discrimination law, as drafted 56 years ago, does it cover sexual orientation? Does it cover gender identity? And hearteningly, both sides in that debate, they applied textual analysis, but as we know, they reached polar opposite conclusions.
You know, when you mentioned the strange experience of going to law school and reading all these judicial opinions where the judges are trying to find the best answer, but without any real recourse to the text, I reached back to my bookshelf because I always keep handy another book by Scalia called A Matter of Interpretation.
Yes.
And his opening essay, it's called Common Law Judging in a Civil Law System, where he sketches out the same basic problem that schools often don't teach young lawyers to actually read laws. They teach them to read judicial opinions, and it's a little different. Judge, we had talked about a couple other questions. We had bounced around, but if you'll excuse me for going off the script, you've sort of dangled something I can't help but ask about. It's this reading list. Are there other books that you would encourage? Because I know there are some law students tuned in and some aspiring law students. Could you maybe suggest a few other readings that you recommend to your clerks or that you would recommend in general?
It's a great question. It is probably a 4 to 5 page reading list divided essentially into two parts. There's a kind of legal and judicial writing section, and then there's a sort of a legal and judicial philosophy section. But there are about 5 books that I keep closest to me. Hold on one second. I want to grab them.
You're going to reach out. You're like disappearing into the corn, like in Field of Dreams.
Yeah.
With your fake background.
There are 5 that I reach for most frequently. One is this one, which you just shared. This one I read this probably once a year. Yeah. And I've read it probably 25 times. And I read it annually as kind of a philosophical, jurisprudential, methodological, like a booster shot almost. And it's meant to just kind of get reacquainted with these really indispensable first principles that Justice Scalia, this is such a readable book. And it's kind of a one-sitting book. It is eminently readable and discerning and just kind of brimming with a lot of incisive kind of wit and insight. Also, having served on the Texas Supreme Court for a dozen years, as you mentioned, our friend Jeff Sutton of the Sixth Circuit. Can y'all see this book?
It's fading a little bit into your background.
It's called 51 Imperfect Solutions.
Yeah.
States in the Making of American Constitutional Law, written by my colleague on the Sixth Circuit, Jeff Sutton, a former Scalia clerk himself. Jeff wrote this book a couple of years ago, and I think it is magisterial. It is really good. I think he's the perfect messenger for it. He is a scholar of the First Order and a judge of the First Order. It is a fascinating book about this critical, underestimated role that states and state judiciaries have in creating our vast body of American constitutional law. You know, we have more than one constitution in this country. We had 51 of them. And it is sort of legal malpractice for lawyers to kind of disregard this front and center role that states play in kind of the legal landscape in our compound republic. So Jeff Sutton's book is fabulous. This, of course, is Reading Law, which is kind of an interpretation book on how to best and most astutely read legal language. And this book, I've got dog-eared, I've got highlighted and underlines of my highlights and highlights in probably half a dozen different colors. But my total list is probably about 4 to 5 pages, but it's a combination of legal writing and legal philosophy. But I have them go through it all before they land on my doorstep.
You know, I had the pleasure of reading the Sutton book. I reviewed it for the Weekly Standard a couple of years ago, and that I agree with you totally. That's just a great, great book. As it happens, Judge Sutton is the co-editor of the new volume of Scalia Opinions that's coming out in the fall with Ed Whalen from the Ethics and Public Policy Center. So it's a real treat. So we've just crossed the 5:30 mark, and I think we ought to move to the student questions. There are 3 students who've already teed up some questions. I have them here, but I think we'll introduce them and they can ask their question. The first up is Pierce Gillen from Baylor University.
Hey, sick 'em Bears, Pierce.
Sick 'em, yeah. Judge Willett, thank you so much for speaking with us today. It's a real honor.
Thank you.
In your concurrence to Patel, you argue economic rights are often treated as second-class rights, a situation that has been perpetuated by a majoritarian impulse on the part of judges. So I was wondering, how optimistic are you about greater protections for economic liberty going forward? Are judges embracing the arguments found in Patel and those made by other justices such as Clarence Thomas, or is this still an uphill struggle?
I think it's fairly uphill, honestly. Uphill as in near vertical. I would not say that I'm optimistic. I am hopeful always, but probably not optimistic. But frankly, given the tougher legal landscape on the federal side, because of course they apply the very deferential rational basis test. But given the tougher legal landscape on the federal side, I think these cases are far more likely to be brought like Patel was in state court and not federal court. Patel itself was brought in the Texas judiciary under the Texas Constitution. And the lawyers who brought it are very sophisticated and they are very entrepreneurial. And they knew their case had a far greater chance to succeed in state court on state law grounds than if they kind of trotted into a federal court. So, and again, Patel was kind of this loud reminder that not all, in fact, not nearly all constitutional law comes from the federal Constitution. As I mentioned, America has 51 constitutions, not just one. And again, if you haven't read Judge Sutton's book, then you certainly ought to have it on your nightstand. It does a masterful job at really kind of stepping through, again, this underestimated role of states in crafting our landscape. And we do live in this compound republic, as I mentioned, and that is a bedrock tenet of federalism, how power is not concentrated in Washington, D.C., but it is separated not just horizontally among the branches, but vertically in order to secure liberty. And American constitutionalism is about far more than what happened in Philadelphia 233 years ago. It's also about what happens in state capitals from sea to shining sea. And the oath that I took when I joined my former court required me to preserve and protect and defend not only the Constitution and laws of the United States, but also of the state of Texas. And I think sovereign states have distinct roles, they have distinct responsibilities within our system. And there's no question the US Supreme Court, they hog the limelight, especially around June, but it's really impossible to overstate the contributions of state courts to the defense and to the articulation of constitutional values. And, you know, Texas, we're an independent sovereign, as we're proud to kind of beat our chest about. We have independent constitutional guarantees. And my former court, the Texas Supreme Court, is the ultimate once and for all arbiter of what the Texas Constitution means. Patel had nothing to do with the US Constitution, had nothing to do with the 14th Amendment. It had everything to do with the Texas Constitution, Article 1, Section 19, which my former court had yet to really articulate a governing test. And Article 1, Section 19, importantly, it was enacted just 2 short years after the US Supreme Court had declared in the slaughterhouse cases that states possessed the power to protect their citizens' privileges and immunities, including the right to earn a living. So in short, my court in Patel, we were construing the Texas Constitution, which was enacted at a different time by a different people with different priorities, with a different history, using different language. And there are, to be sure, there are some state courts that do interpret their constitutions in lockstep with the federal Constitution. But Texas is not one of those. And Texas, of course, like every other state, is absolutely free to add to the liberties of their citizens. And the people of each state, you know, they use their own constitutions to uniquely provide protections of liberty that are in addition to the guarantees that are provided in the federal Constitution. So there's just one example. Long before the US Supreme Court decision in Heller, the Second Amendment case, 39 state judiciaries had already interpreted their state constitutions to say individuals have a right to keep and bear arms. I mean, one more example, there was a 1990 US Supreme Court decision in Employment Division v. Smith. So after Employment Division v. Smith in 1990, a dozen state Supreme Courts held that their state constitutions provide greater protection for the free exercise of religion than the Supreme Court recognized in Smith. So, I mean, federal courts, when it comes back to occupational licensing, they are currently split on how to apply rational basis to certain occupational licensing laws. I mean, my current court, the Fifth Circuit and the Sixth Circuit, even under deferential rational basis review, they have struck down laws that say you have to be, for example, a licensed funeral director to sell a casket. The 10th Circuit, by contrast, has upheld such a law. So, I mean, I readily accept that states have a sweeping, what we call police power to regulate in the public interest. And I said so unequivocally in Patel, that nobody really seriously disputes a state's omnibus power to safeguard their state's health and safety via economic regulation. The US Supreme Court has struck down occupational licensing stuff too, not recently, but back in 1957, they held unanimously that people have a 14th Amendment right to earn a living, and they struck down the state of New Mexico's refusal to let somebody sit for the bar exam because they were a professed communist. So again, the Texas Constitution, it was enacted in the immediate wake of the slaughterhouse cases, which were back in 1873. Slaughterhouse underscored that states possess a wide power to protect their citizens' privileges and immunities. And I think that's an important reservation of rights to the states that the drafters of the Texas Constitution just 2 years later were undoubtedly aware of. And so, long story short, I'm not really optimistic that anything is going to change anytime soon on the federal level. But I think entrepreneurial lawyers looking to strike down burdensome economic regulations are probably tactically and strategically smarter to go knock on a state courthouse door than a federal courthouse door. And it's interesting, in the wake of kind of the pandemic, all the COVID craziness, you see states kind of loosening regulatory barriers. And I'm interested to see, as a ripple effect of all this, what might stick and what might be sort of lasting reforms.
You know, there's a saying, century-old saying, that states are laboratories of democracy. And in a way, what you just described, states are laboratories of liberty, right? As they show how their constitution, separate from the federal constitution, can chart a different course. Well, thanks. That's a great question. Our next question is from Mendel Jacobson from Central Chabad Yeshiva.
Hi, Judge Willett. I have a similar question to Mr. Gillen's regarding economic rights. In 1984, Justice Scalia famously debated Richard Epstein on judicial protections for economic liberty. And Scalia argued for greater judicial restraint because he worried about, quote, the effects of such expansion on the behavior of courts in other areas quite separate from economic liberty, and the ability of the courts to limit their constitutionalizing to those elements of economic liberty that are sensible. In your judicial opinions, you have been more sympathetic to protecting economic rights. Do you think Scalia was correct on this issue? And how does your approach protect against the dangers he describes?
That's a great question. And Adam, did you give them sort of an abbreviated version of Patel? You didn't subject them to the whole 52 pages, did you?
We gave them more than we left out, that's for sure. And we were sorry to have to cut any of it. But we did cut that much. Most of it's in there.
If y'all have trouble nodding off tonight, then pick it up and read it through. I do go through there kind of the kind of these commonly voiced objections that, gee, is this sort of opening Pandora's box? And I and some of my dissenting colleagues had a pretty collegial but spirited back and forth about that. There's no question, judicial activism is real. It's not imaginary, but also real is judicial passivism, in my view. And in some ways, this charge of judicial activism has a certain slipperiness to it. Justice Kennedy, he once said it really depended on whose ox was getting gored. He said, an activist court is a court that makes a decision that you don't like. And lawyers will often argue, my opponent's argument is an invitation to engage in judicial activism. And the other side will make often the identical verbatim charge. We saw that in the very first Obamacare case at the US Supreme Court, where both sides were arguing that the other side was inviting the court to engage in judicial legislation. So I think this term judicial activism is kind of a legal Rorschach test, a Rorschach test where you look at ink blots and say, I see a dragon or a football or whatever. But as I wrote in Patel, I oppose judicial activism, which I define as inventing, concocting rights that are not rooted in the law. But the opposite extreme, undue judicial passivism, I think is also corrosive. I think it's also corrosive for judges who perhaps, while not activists, or maybe not also properly active in preserving the limits and the liberties that our framers actually did enshrine in the Constitution. So the Texas Constitution, which again is what we were interpreting in Patel, it is irrefutably framed in the language of proscription. Government, you cannot do this, you cannot do that. And it imposes very unsubtle, unmistakable limits on government power. And it models the federal Constitution, in a pretty fundamental way, it divides power so that every branch kind of checks and balances the others. But the framers, both Texas and federal, they opted for constitutional government, meaning limited government. And it enshrined these structural principles that are not there for mere show. They're not kind of embellishments. They're there for a purpose. And in the Hall of Presidents a few years ago, I was with my kiddos at Disney World, and they were introducing all the presidents in the hall. And they got to animatronic Calvin Coolidge. And I went, woohoo, for Calvin Coolidge. And my kids were totally mortified. But there's this great Coolidge quote that is so wonderful. And I think I think he understood this ineffable genius of what happened in Philadelphia 233 years ago. He said, to live under the American Constitution is the greatest political privilege that was ever accorded to the human race. And I agree with that. I do think the dangers of judicial activism are ever present and always will be. I think there will always be judges who view the law as wet clay that they can mold and shape and fashion to reach whatever result they desire. And my own view is, as judges, we have no business second guessing the policy choices of elected lawmakers. But when constitutional rights that have actually been enshrined, when those rights are imperiled, I don't think it's impolite to tell government no. I think it's our duty to tell government no. And I don't think judicial restraint requires judges to ignore the non-restraint of other branches, not when their actions endanger constitutional liberties. I think that's precisely why the Constitution was written, to keep government on a leash. So my supreme allegiance as a judge is to the Constitution. That's the trump card in our American system. And the political branches, they decide if laws pass. But as I wrote in Patel, the judiciary decides if laws pass muster. And if a liberty that's in the Constitution is put in danger, I think this excessive permissiveness doesn't really have any place. And lawmakers, they have primacy when it comes to kind of regulating or enacting laws that govern our day-to-day affairs. So they have policymaking primacy. That's where the center of gravity is. But preeminence doesn't equal omnipotence. And I think there has to remain judicially enforceable constraints on legislative action that is irreconcilable with constitutional commands. And I think if judges are too unduly permissive, in my view, I think that sort of deference can devolve into dereliction. And I think that sort of adjudication can more resemble abdication. The judiciary, as I've written on my former court and my current court, we're a constitutional partner, but we're not a junior partner. And while we should always be respectful of the political branches, we should never be beholden to them.
You know, for folks who are interested in reading that debate between Scalia and Epstein, it's available online. You just need to Google, I think, Scalia versus Epstein, and it's available on a PDF from the Cato Institute. Thanks, Mendel. Our third question is from Daniel Bring of Dartmouth College.
Judge Willett, thank you so much for joining us this evening. It's a great privilege to hear you speak. So the growing popularity of so-called democratic socialism has brought policy proposals for economic redistribution, such as a wealth tax, back into the realm of political possibility in America. How do you think that the judiciary can restrain these potential infringements to economic freedom, even as they gain cachet in the electoral sphere?
Daniel, thank you. I got to ask you, is that your home library in the background there?
I wish. It's a Zoom background of Baker Library at Dartmouth.
Very good. You know, as I mentioned earlier, the role of the courts is consequential, certainly, but it's also confined. And you know, courts like mine, we take cases as we find them. We don't orchestrate litigation. We don't engineer it. we simply respond to whatever lands on our doorstep. And the Constitution, it expressly limits our review as federal judges to specific types of cases and controversies. And when I was a judge on my former court, the Texas Supreme Court, one satisfying feature of that service was I was the final word on what Texas law is and means. And if I thought, and my colleagues thought, that earlier precedent got it wrong, we could push the constitutional reset button and we could set things right as we saw it. But as a US Circuit judge, I'm just middle management these days. And I've got to salute smartly, and I've got to follow binding precedent even when I disagree with it. Generally, under prevailing precedent, Congress has pretty broad authority in the area of taxation. And the disputes surrounding tax policy, unless there's some kind of discrimination built into it, are generally more political than judicial. But here's the genius, this ineffable beauty, again, of what happened over those 4 sweltering months in Philadelphia way back when. You know, we the people wield ultimate sovereignty. So you've all heard the story, right, of Benjamin Franklin. He's leaving Independence Hall. He's triumphant. He delivers the last major speech of his life that day. He's in his 80s. He's actually too sickly and frail to deliver it himself. He has another delegate kind of read the speech on his behalf. But he got his way, and they voted to approve the new Constitution. And so he's exiting Independence Hall, triumphant. This woman, Mrs. Powell, rushes up. You've heard the story. Well, doctor, what have we got? A republic or a monarchy? And you all remember his famously kind of sharp-witted reply, a republic if you can keep it. And it was a zinger. It was heartening, right? So no more royal absolutism, no more imperial commands. So it was heartening. But it was also ominous, because after a republic came, if you can keep it. And it was ominous because it suggested that the survival of freedom depends on people, not on parchment, but on people. And the framers, God bless them, they were not tinkerers. They didn't kind of fiddle around the edges. They upended things. They were imperfect, as we all are, but they were inspired. And the Revolution and the Constitution, it introduced this revolutionary design. It had this Madisonian architecture, but as I wrote in Patel, it was really infused with this Newtonian genius, these 3 separate, independent, co-equal branches of government kind of locked in the synchronous orbit, held there by competing interest. It was ambition counteracting ambition, as Madison famously put it. But the really extraordinary element is that those 3 rival branches all derive their power ultimately from those 3 unrivaled words that are printed in supersized, can't miss it script at the very top of the page, we the people. And this was an era of kings and of sultans. And in that age, nothing was more radical than this idea that ultimate sovereignty resides not in the government, but in the governed. And popular sovereignty is not just a theory. I mean, it's really a duty. I mean, Jefferson, he wasn't at the convention, but he wrote from Paris a couple years later. He said, wherever the people are well informed, they can be trusted with their own government. And I think that prognosis, it really kind of underscores what the Constitution really presupposes, is that this enlightened citizenry is really indispensable to American self-government. But you fast forward a couple of centuries, and we the people's kind of civic illiteracy is really staggering. You know, 71% of Americans can't identify the Constitution as the supreme law of the land. 10% of US college graduates think that Judge Judy sits on the US Supreme Court. Roughly only a third can name all 3 branches of government. Another third can't name a single branch of government. So I think Franklin, even as good-humored as he was, I think he would be pretty distraught that this generation of Americans today, with access to the most information, is also the least informed. But even if we were really well informed, that it can't guarantee good governance. And Franklin cautioned if you can keep it, because he knew that this engaged citizenry with their sleeves rolled up was the secret sauce. Again, it's we the people. It's not we the government. It's not we the judges, not we the subjects. And citizenship, as I put it sometimes, is not a spectator sport. And Justice Brandeis, who served on the court almost a century ago, I think put it really well. He said the only title in our democracy superior to that of president is that of citizen. So our Constitution is this exquisite charter of freedom, but freedom requires patriots and not passersby. And it demands fierce defenders and not feeble bystanders. And Margaret Thatcher, she once put it, first you win the argument and then you win the vote. So if you want to triumph, whether it's on tax policy that you mentioned or anything else, you got to do your homework, and then you got to outwork and out hustle and outthink, out strategize those on the other side. So I think on tax policy specifically, I think fools need to kind of roll up their sleeves democratically and take a lesson from the Iron Lady. But we the people, we've got the oldest written national constitution on earth, making America the oldest constitutional republic on the planet. And I think we'll stay that way if we can keep it. But again, citizenship, not a spectator sport. And I'm really inspired and encouraged by you guys who are kind of taking max advantage of your time and trying to enlighten yourself and kind of expand your philosophical toolkit and be as sharp and versatile as you can be. I'm really envious. Nothing like this was really around when I was your age, a quarter century or more ago.
The feeling. Thanks, Daniel, for the great question.
Thank you.
We have a question now from Elana Quint. She's a student at the Georgetown Law School, and she's the program manager for Professor Randy Barnett's Center for the Constitution. And I remember Elana from my class last summer on conservatism and American constitutionalism. So welcome, Elana. Please ask your question.
Thank you. Nice to see you again, Professor White, and thank you for joining us, Judge Willett. So actually, funny to start off, one of our alumni from the Originalism Summer Seminar is actually one of your current clerks, Nick Mills. And I had an opportunity to interview him only 2 days ago, and he could not speak more highly of Judge Sutton's book. So that's a great endorsement. But as for my question, I'm going to be starting law school this fall in the evening program. And the question I wanted to ask you is, how should judges approach issues of stare decisis when it comes into conflict with the original public meaning as you see it?
Yeah, it's a great question, Elana. Thank you for that. Actually, as you were speaking, Nick just walked by my office window. Obviously, he doesn't know I'm talking to you, but Nick is a superstar. And you may or may not know, he was recently hired by Justice Kavanaugh to go clerk for him October term 23. So Nick's going to go to New York and make a fortune, way more than I do, for a couple of years. And then he's actually going to go clerk on the federal district court and get some rollicking district court experience before he lands in DC with Justice Kavanaugh. But he's a star. Another one of Professor Barnett's kind of proteges, Alexa, is also clerking this year. She's an absolute superstar. So tell Randy that more than a few of his books are on my required reading list. Our Republican Constitution and the several others are on there. And so he has a kind of a marquee spot in my list. So you say you're starting law school?
Yes, in about 1 month, most likely online.
Okay. Good luck with that. I know it's kind of an oddball time to be starting. Stare decisis, and when it conflicts with original public meaning. And that's one difference, again, between my current gig and my former gig. When I was on my former court, I have unfettered, absolute latitude and autonomy to push the reset button and get things right, in my view, if I thought the court had strayed before. As a lower court judge on the federal circuit, even if I think the court is absolutely, categorically, no doubt about it, wrong, I've got to swallow hard and salute smartly and go along with it. And that's been one of the key differences between my former job and my current one is I'm not the final word anymore. I think if I were back on my former court, I had more of a Justice Thomas kind of approach. You know, Justice Thomas has a view that, hey, if we got it wrong, we're the Supreme Court, and we ought to kind of recalibrate our precedent and our case law to align with what are the legally correct principles. So on my former court, I had more of a Thomas view, which is, you know, certainly stare decisis matters, predictability matters, stability matters, uniformity matters. And I think especially maybe when you have a statute that you're interpreting, not a constitutional provision, but a statute, because people try to order their affairs to align with judicial interpretations of statutes. And when they order their affairs, they lack certainty. They want to kind of shrink the universe of uncertainty. So I think stare decisis plays an especially important role in matters of statutory interpretation, because also then lawmakers, if they believe your interpretation is bogus, they can go back into session and pass an amendment. They can kind of tweak and refine the law they've passed to kind of, respond to the court's ruling. So if the court blows it on how we interpret a statute, lawmakers can always come back and respond. That's one of the checks they have. They can come back and enact a revised or amended law. The problem with the Constitution is once you sort of constitutionalize something, to say that a right is enshrined in the Constitution is kind of game over at that point. And the Constitution is kind of the trump card of our American design. So those kind of rulings are much harder to remedy. But on my former court, I had more of a Thomas view that was more open and receptive to, again, pushing the reset button if I thought an earlier court or ruling had gotten it wrong. But give Randy my best. He needs to come out of his shell, not be quite as shy and retiring, but actually speak his mind.
Well, on that, he actually is publishing a book on the 14th Amendment that's going to come out in the next year. So stay tuned for that.
I will. I'll add it to the reading list.
Judge, we're up at time. Do you have time for one last question from the students?
Yeah.
So the last question is going to come from Zach Gruev of Harvard Law School. Zach?
Hey, Adam, I'm just going to ask the question on Zach's behalf.
All right, Cheryl, please.
So, Judge Willett, do you have one piece of advice that you would give to an incoming clerk to help them make the most of their experience?
Ooh. Well, in my chambers, you got to devour the reading list and show up thoroughly versed in judicial philosophy and writing. One thing hammering home, not just to my incoming clerks, but to young lawyers generally, is we're all human. Lawyers make mistakes. Mistakes are inevitable, but they're also usually the best learning experiences. And if you handle them with humility, with graciousness, it's actually a great way to earn trust by those around you. And also, what has really served me well so far, both in law school and my career, is this. I'll come back to Calvin Coolidge. He has this great adage that one of my clerks, it may have been Alexa, I can't remember, reminded me recently. Coolidge said, "Nothing in the world can take the place of persistence. Talent will not. There's nothing more common than unsuccessful men with talent. Genius will not. Unrewarded genius is almost a proverb. Education will not. The world is full of educated derelicts. Persistence and determination are omnipotent. So I tell young people to be good lawyers, but to be more than good lawyers. And I tell them to always nourish these noble motives and their high ideals, which prompted many of them to go to law school in the first place. I tell them that as hard as you may be working as a young lawyer, to always kind of cherish your family, cherish your faith, cherish your friends. And I tell them, as corny as it may sound, to commit to making not just a living, but a difference. There's a magic combination to, number one, loving what you do, and number two, believing that it matters, that it really counts in a grand, divine, big picture sort of way. So I tell people to stay unjaded, to stay idealistic, to make room in your lawyer life for public service and for pro bono work, to things that are important to you, but to also for things that are bigger than you. And I forget who said it, maybe my wife, but how you spend your days is how you spend your life. So tackle your days with gladness and with gusto and with gratitude. And also in life, I've come to learn I've regretted more the things I didn't do than those I did do. So keep that in mind. Also, don't dawdle in making sure your priorities are not out of whack. And you got to lavish time and you got to lavish energy on those who matter most. So the law, you'll find, and there may be a lot of future lawyers in this audience, the law is equal parts exhilarating and exhausting, right? It is daring, but it's also daunting sometimes. But you got to remember always that the law is about real people who are walloped by real problems in the real world. These are flesh and blood people who are often frail, who are often afraid. There are people who are depending on you. And that is a monumental responsibility to hold lives and to hold livelihoods in your hands. So I tell my clerks to be kind, to treat people well, and to always keep your eyes open for ways to champion the least and the last and the lost.
Great. And last question from Michaela Peters from American University.
Sorry about that. In navigating disputes over interpretation and facing disagreement, even among judges of your own party, have you learned any particular communication practices which you find helpful or most effective to move past polarization and reconcile enough to at least reach a conclusion and fulfill your duties as a judge?
I do work on a collegial multi-member high court. And my former job, there were 8 of us that I had to sort of play Mother May I with. But we all officed down the hall from each other. So we were geographically all sort of kind of gathered pretty close together. And you saw a lot of them. So we would have argument during one week, and then we'd gather in conference and sit around our ornate conference room around the table, and would go around the table talking about, discussing our cases and how we thought they ought to be decided. And things got very kind of spirited, sometimes feisty, animated, and rarely in a pejorative, kind of below the belt sort of way. It was always about principle, about the even-handed, as we saw it, application of principle in a no favorites fashion. But we differed and we bickered, respectfully, collegially, but we parted company, and people were not at all bashful about expressing sharp disagreement. My current job, I sit in a 3-judge panel. So there are 2 other colleagues I'm deciding cases with. Roughly 90+%, maybe close to 95% of our disputes, of our cases rather, are decided 3-0. I think people would be stunned at that level of unanimity. I don't think that's unique to my circuit. I think that is probably a pretty consistent average across the circuits nationally. So we sit in 3 judge panels, but unlike my former court, we were all, I guess, judicial conservatives in the general kind of big tent meaning. But it was sort of a Kennedy to Thomas spectrum. My new court, there's a lot more ideological diversity on my current court. There are 17 active authorized judgeships on this court. 6 of those 17 were appointed by President Trump, but we have 10 senior judges who are all pretty active and they sit frequently. Most of my panels will have a senior judge on them, but you may have judges appointed all the way back to President Carter, all the way to the president. Judge Reevely just marked his 99th birthday, and he is still working and deciding cases, a Carter appointee. He's married to another Carter appointee, Judge Carolyn King. It's a great romance. You ought to Google Tom Reevely and Carolyn King romance, and it's a beautiful story. But there's a lot of ideological diversity from Presidents Carter all the way to the current appointees of President Trump. So the panels are geographically scattered, a little more ideologically kind of eclectic. But even having said all that, the overwhelming bulk of our cases are 3-0. So federal appellate judging is a pretty collegial world, and the dominant impulse is consensus, and separate writings are the exception and not the rule. But my role, as I view it, isn't just to decide cases, but to decide them correctly, in my view. And if I do believe my colleagues have reached the wrong answer, or maybe the right answer, but for the wrong reason, I may conclude I've got a duty to write separately. And maybe not every time I have a quibble, because sometimes I think for the greater good, you kind of suffer in silence. You don't want to be a chronic dissenter who simply must always be heard on every disagreement, however kind of trivial. I think that weakens your voice, and I think that kind of siphons your kind of potency and effectiveness on the court. So you have to kind of pick your battles. But I think disagreements that are respectfully explained, I don't think that detracts from the prestige of courts. I think it shows that judges are earnestly grappling with thorny issues in a principled way. I think that's what makes the judiciary, in my view, the most elegant branch of government. We're the only branch really expected to explain why we're doing what we're doing. And the other branches, the political branches, if you have enough raw political power at your disposal, you can just ram and jam and cram through whatever you want without a lot of accommodation or moderation or explanation. And the judiciary is different. We're the only branch really expected to explain step by step, methodically, why we're doing what we're doing. So a judge, when I write, I think I've got, especially a dissenting or a concurring opinion, I've got multiple audiences in mind. My colleagues on the panel are the most immediate audience because I want them to kind of respond to what I've said. I want to kind of sharpen their opinion by critiquing it. Maybe I'll change their mind, or maybe my writing will improve the majority opinion. Or maybe I can do some damage control and maybe emphasize the limits of that majority opinion. Maybe I can send a warning flare to other circuits around the country if this issue arises in their court. Or I could call for kind of legislative reform or something, as I've done with qualified immunity. My audience, it may be the broader legal community, it may be the larger public, it may be other branches, it may be colleagues who weren't on my 3-judge panel, but who may be persuaded to vote in favor of rehearing the case en banc before the entire 17-member court. So sometimes they're my audience. But judges occupy a pretty unique and center stage role in the intellectual development of the law. And I don't think it ought to be left to academics with apologies to all my friends at academia. And I actually like writing separately because you can speak in your own voice. You can say things the way you want to say them without having to play Mother May I with a lot of other smart, willful, opinionated people who want to sandpaper your work. And when I do write, Adam was overly generous earlier about my writing, but I try to write for a smart lay audience, and I, above all, want my work to be reader friendly. I try to be conversational because I think accessibility enhances legitimacy. So I write to be understood, and I aim for clarity, and I aim for simplicity. And I think the bullseye for judges is taking something complex and explaining it in an accessible way without sacrificing substance. So it's clear and concise and engaging, no kind of ponderous legalese. It is a legal document, but it doesn't have to be this tedious kind of dirge almost. And I don't really try to emulate anybody. I just try to write readable, scholarly, kind of jargon-free opinions that non-lawyers can understand. So I think I'm pretty fluent in legalese, but I don't want a lot of dense and ponderous prose kind of clogging my work. So I try to marry down-to-earth writing with strong legal analysis. And where I can, I try to sprinkle it with maybe some well-placed verb and amiable kind of phrasing here and there. But I think I learned, in terms of writing, I think I learned from judges across the spectrum. I mean, I certainly enjoyed Justice Scalia's gusto and those occasional pyrotechnics, but I really admire Justice Kagan's conversational style. She is a crackerjack writer. She is really a brilliant wordsmith.
Well, thanks. That was a great question. And Judge, thanks for taking all this time today to talk with the students and give them a window into the life and work of a judge.
I've thoroughly enjoyed it. Thank you all so much. Good luck to everybody.